it please the court. I'm Leslie M. Conklin, and I represent Bloomingdale Trail Homeowners Association, Inc., one of the defendants below, and the appellant in this case. This case comes before you on an appeal from an order denying the appellant's motion for attorney's fees under 57.1051 after a non-jury trial in July of 2015. And, Your Honor, the facts of this case are that in October of 2009, Bank of New York files a complaint for mortgage foreclosure, count 1, and for reestablishment of a lost note, count 2. Forgive me, I did want to reserve 3 minutes. Thank you. And count 2 for a lost note. So they allege that they're not in possession of the original note, and Bloomingdale Trails in its answer admits that. They're not in possession. The copy of the promissory note attached to the complaint doesn't have an addendum to it, a prepayment addendum. Also has no endorsement or a launch. So case progresses, and at that time we raised in the answer to affirmed defenses that they had no standing. Same time served, but did not file, the motion for 57.105 attorney's fees, claiming that you don't have standing. I mean, we pinpointed it. I liken these cases to a game of pool. I not only have to sink the shot, I have to call the shot before I sink it. And in this case, the 57.105 in 2009 says you don't have standing.
But at trial, I don't want to second guess what counsel was doing, but if I think it's the pooling agreement. If the pooling agreement had been properly entered into evidence, standing problem would have been taken care of. Is that correct?
I don't know that at all, because keep in mind, the pooling and servicing agreement didn't come into evidence because it was unsigned. It had no signatures on it. I don't know, and I don't think that witness could have testified that this was an agreement. The point being, what's the evidentiary value whatsoever of an unsigned contract? How do I know it's not a draft? It's nothing. So I have trouble with, the ruling in this case, and the ruling in this case was basically, Judge Taylor says, well, I'm not even sure that the plaintiff didn't have standing, but through lack of preparation and diligence, you just didn't prove it. And here's the problem. The judge is looking behind her own order of lack of standing. Keep in mind, I won the case. I didn't lose the case. So the lower court simply denies attorney's fees on the basis of a belief that they had standing, but Bank of New York and its attorneys simply did not try a case sufficiency to be liable for 57.105. And so my question that I stated in the brief was, how could a trial court look behind its own ruling as to Bank of New York's lack of standing? She says, I'm not even sure they didn't have lack of standing. They just did a lousy job of trying this case. Wow. I didn't understand this. This was not just merely a case of losing and another side winning. This was a case where we have an unverified complaint in 1999, no copy of the promissory note with an endorsement or a launch, doesn't even have the addendum attached to it, and 6 years later, we come to trial and we have a witness who can't testify that the endorsements were put on the note prior to the commencement of the case. Certainly we can't say that the then existing law provided that, there was some exception here. In Madel versus Wells.
Is that a failure of proof at trial, or is it a concession that at the time they filed the complaint, they knew that they lacked standing? Those are two different animals, aren't they?
Yeah, but I'm not sure what result it is. The point being, when the witness cannot state when the endorsements were put on the note, and I agree with all the case law that says you don't have to testify as to the exact date, but it has to be prior to the commencement of the lawsuit. The point being, how do we know the endorsements were put on afterwards? They don't find the note for 2 years. At trial, there's no explanation as to where's this note. I seriously at night kind of run through my head of where do all these notes go? I mean, do I go to a telephone pole and I see a poster there that says, have you seen my note? Reward given, no questions asked. Where's the note? They have no explanation as to that. And two, in 6 years of trying this case, you didn't ask the witness prior to trial, are you going to be able to testify when these endorsements were put on? And when she isn't able to, is the presumption that, well, they're just not able to prove standing? Or is the presumption, you didn't have standing, you put the endorsements on afterwards when you found the note 2 years later?
So
We don't know.
Whose decision was that to assess? That was the trial judge.
No, I'm saying that doesn't,
I mean, the trial judge made a decision that what we had here is inadequate preparation for trial. And I'm trying to figure out how that is going to trigger a rule that's going to expose a party to 57105 fees.
well, keep in mind, in 1999, the statute is amended, and it says if you do not have the support of the material facts at any time during the case, not merely at the commencement, and that's shown in the case of Albritton versus Farrar, which I've cited in the brief, 1st District, 2005. Quote, once a party learns its claim or defense is not supported by the facts or law, it must drop the claim or defense or risk imposition of 57105 attorney's fees on the non-meritorious claim or defense. Same ruling, by the way, that this court had in Ray forfeiture of 1997 Jeep Cherokee. That was the case where City of St. Petersburg police pulls over a lady in her Jeep Cherokee, makes a determination that this is her third, stop, and therefore they're able to take forfeiture of the car, and she wins on summary judgment because they withdraw their claim just prior to the hearing on summary judgment. There had only been 2 convictions, not the necessary 3, but the court denies attorney's fees, saying, oh well, the City of St. Petersburg, in good faith, had brought this, and plus, at the preliminary hearing, had found probable cause. This court reversed and said a simple review of the record would have shown you didn't have the requisite basis of the 2 convictions, and reinstated the 57105 attorney's fees claim for the nice lady, Mrs. Allen. So, the point is, in this case, in 6 years' time, we don't have, by the plaintiff, anybody who says, can we find a witness who's going to be able to testify when these endorsements were put on? Because certainly there's no argument by the plaintiff, by the appellee in this case, that Bank of New York, that the law was not well settled on this. That if you filed a case with a promissory note that had no endorsement on it, sometime during the case you're going to and you're not the original lender, sometime during the case you're going to have to prove when that endorsement was put on the note. And I cite in my brief the case of Madel, where the 5th District says, do we have to say it again? So, the point being, in 6 years' time, nobody asked the question of do we even have a witness who's going to be able to date these endorsements? And of course, when I get the woman on cross-examination, Bank of New York Mellon's representative, I've never even seen the original promissory note. No, I wasn't there when it was, found. I wasn't there when it was endorsed. I don't know the answers to these questions. So I win the case, and then Judge Taylor says, well, lower court denied fees simply on a belief that the Bank of New York had standing, but Bank of New York and its attorneys simply didn't do an adequate job at trial to prove that. I defy the judge below or this court to find one piece of admissible evidence that shows standing. There were only 4 documents admitted into evidence in this case: the note, the mortgage, the default letter, and the payment history. 4 documents. In fact, it'd be hard to win any case in foreclosure with just those 4 documents, but they didn't have it. So, here we have a series of cases talking about what do you need to prove a 57105, and we have guidance. As amended, 57105, quote, does not require a party seeking fees to show the complete absence of a justiciable issue of law or fact, but permits fees to be recovered for any claim or defense that is insufficiently supported. That's Long versus Avmed, 1st District Court Case 2009. Quote, supported by material facts, the requirement in the statute, means the party possesses admissible evidence. I repeat, admissible evidence sufficient to establish the fact if accepted by the finder of fact. That's a Burton versus Ferrara. Same court that also says if we can award attorney's fees for failure to have material facts or then existing law at any time prior to trial. And that's my whole point of, in 6 years of this case, we don't find out until the verdict that in fact we don't have the evidence to support the claim of standing. Wow, this is an uphill battle in view of the fact that 6 years prior we file a complaint that has a promissory note that doesn't have an endorsement, doesn't even have the addendum attached, and we say it's lost. It's an uphill battle after that. You should have been certain, absolutely certain going to trial. I have a witness who's going to be able to date the endorsements. I have a PSA that was actually executed. I don't think that's too much of a burden, too much of a standard for 57-1051. And yet, as I say, in this case, the court denies standing and says, oh, well, I'm not even sure they didn't have standing. I don't know how she could have made that statement. The point being, I think she was distressed at the way the trial went, and it didn't go well. And if you read, like my last thing, you don't get the full import of it, but at the end, when they rest their case in chief, I say, do I even have to make a motion? And she goes, go ahead and make the motion. And it's like the case completely fell apart. Keep in mind, it wasn't just this issue. There were other issues in the case. They attempted to introduce a modification into evidence which wasn't pled, and Judge Taylor excluded the modification. So there were a lot of problems at trial, but isn't that what 57-1051 is all about? And that is, as I say, there's no dispute as to what the law was. The law had been crystal clear and repeated by all of the appellate courts, including this one. It said, if you're not the original lender and you're relying upon an endorsement in blank, you need to show the endorsement occurred before the commencement of the case. And the second part, wow, you need a fully executed document if you're going to have it admitted into evidence. That shouldn't be a surprise. That shouldn't be, so forth. My point is that she says this case was through a lack of diligence. I want to get the exact words that she used. Rather, plaintiff, through evidentiary issues combined with a lack of preparation and diligence, failed to meet its burden to prove standing at trial. Isn't that exactly what we're talking about with 57-105? If it isn't, then I don't know when we're going to apply this statute anymore. Thank you.
Thank you, Mr. Conkle.
Good morning.
Good morning.
May it please the court, Dario Abrahami on behalf of the Appellee with Greenspoon Martyr. The question this court needs to answer is whether the trial court abused its discretion in denying the motion for 57-105 attorney's fees. The answer is no. The trial court did not abuse its discretion in determining that the bank did not know and shouldn't have known that the bank did not have standing at inception. The trial judge here, who was the same trial judge who actually conducted the trial, was in the best position to make that determination. And after hearing argument from the appellant during the hearing, the court determined that the bank shouldn't have known that it didn't have standing. What the appellant's trying to have this court do is make a rule that simply losing at trial is enough to warrant 57-105 attorney's fees. And that's not what the standard is in Florida. The standard is...
Well, it's not so much losing at trial. If I hear Mr. Conklin's argument correctly, it's doing such a poor job. There are things he's saying that the bank should have known and should have developed, and for whatever reason, they failed to do so.
I understand, Your Honor, and I can accept that and appreciate it. The difference is that's a failure of proof. And what appellant is trying to argue is that not being able to prove your case at trial rises to the level of, in essence, having a frivolous claim to warrant 57-105 attorney's fees.
What evidence was presented that these signatures were signed, the signatures were placed on the note prior to the inception of the case.
At trial, the only evidence was actually after the trial when the bank moved for rehearing. There was the consent and waiver filed by the borrower who waived standing and acknowledged that the bank did have standing. At trial, there was no evidence of the signatures before. There was the original promissory note with the endorsements, which proved standing at trial. So it's not like the bank...
But that's your main case against the borrowers.
Right. That's kind of where I'm going with this.
But the issue is that there were blank endorsements and the original note introduced at trial. So at a minimum, there was standing at trial. This isn't a case where the bank had a closed endorsement note and tried to come and prove its case and would have never been able to win at all. Here, the bank actually had the note with the blank endorsements, but through a witness who was only there for 2 years and wasn't with the bank in 2009 when I believe the 57-105 motion was served, wasn't able to testify based on knowledge or preparation that the endorsements were made back prior to the complaint being filed.
What would have been the effect of the loan modification had the trial court admitted it into evidence?
If there was a loan modification and that was entered into evidence, I believe the bank would have had standing. The bank would have had standing if there was a loan modification.
What's the legal basis for that argument?
If the loan modification was entered into evidence and the bank was able to authenticate the loan modification,
Okay.
and prove that these are the terms of the loan and the witness was able to testify,
Okay.
then the terms of the loan modification would have controlled the loan and the bank would have presumably had standing at trial and based on this loan modification. But the issue at trial in this case was, and the reason that the HOA was dismissed, was the bank couldn't prove that it had standing against the HOA. Through evidence, there was never a determination that the bank did not have standing, period. The judge never ruled that. The judge just said this witness was only working for the servicer for 2 years. We had an unsigned pooling and service agreement and mortgage loan schedule that was unsigned, so there's no proof to show that you had standing at inception. It's entirely possible that the bank did have standing at inception, but the bank wasn't able to prove it. And that does not warrant 57-105 attorney's fees in this case.
Please correct me if I'm wrong, because we've read lots of these. There was an agreement between your client and the original property owners regarding almost a consent to judgment of foreclosure. But as I understand the record on this case, it wasn't introduced in the evidence because counsel for the bank didn't know it existed and had to come back later on after the final judgment to correct it. Is that correct?
That is correct. It was sent to the bank's counsel's
So actually,
office.
at the time of the trial, there was no proof of standing at exception whatsoever. That was a curative thing that took place later.
That's accurate.
Okay. Our court has said a claim is supported by material facts within the meaning of the statute when the party possesses admissible evidence sufficient if accepted by the finder of fact. We've written that. Judge Kelly, I think, was the author of the opinion. Casey, what admissible evidence did you have at the time of the trial? Is that the admissible evidence that somewhere within the voluminous files of the bank we had this from the borrower? We just neglected to tell anybody about it until after the trial was over?
No, that's not the admissible evidence.
So how is a servicing agreement that's unsigned going to be admissible into evidence in the absence of some sort of stipulation or request for admission? I mean, most law students know that an unsigned document's not going to be proved that there's a contract between the parties. So that's obviously not admissible evidence. So my question is, what admissible evidence, if that's the test, did you have at possession of your client at trial to get it in?
The bank did not have admissible evidence to prove standing at inception at
Well,
trial.
if they had no admissible evidence, and the standard is admissible evidence, based on that case, do you lose?
No, because the determination is made at the fee hearing. And at the fee hearing, the judge exercised her discretion in determining that the HOA didn't sustain its burden to prove that the bank didn't have any admissible evidence at trial. It's entirely possible that the bank did have admissible evidence.
The argument is that the movement failed to establish, by reason of the evidence admitted or not admitted at trial, whether or not under the statute, the claim was, or defense was initially presented to the court or at any time before trial, they didn't meet that burden of persuasion because they didn't introduce any further evidence other than the evidence admitted at trial.
I would agree with that.
And the standard of review for us is an abuse of discretion.
Correct. Correct. And that's why it's important that the trial judge was the same judge at the actual trial and the fee hearing. The trial judge was well aware of what happened at trial. The trial judge during the fee hearing stated this was a contentious trial. This was a hotly contested trial. There was continuous objections on the pooling and service agreement and whether it was signed or unsigned. The servicer had only been working there for 2 years. And in the judge's discretion, the judge determined that it's entirely possible that the bank actually did have possession of this note prior to the complaint being filed. The association didn't sustain its burden at the fee hearing to prove that there was no question that this was a frivolous claim, that the bank did not have standing ever.
So what you are arguably suggesting is that at the time the movement requests the hearing to be heard, the movement must place the opposing counsel on the stand and ask the opposing counsel what admissible evidence they had at the time of the hearing?
No, not necessarily put the opposing
Well, then
counsel.
how do they meet this burden of proof if, you know, if we're not going to have an evidentiary hearing on the motion where counsel comes up to, if you say has to prove it, it would seem that the best witness he would call would be, say, his opposing counsel and say, at the time of the trial, tell me what admissible evidence you had. And then if he says or she says none, then they prevail on the motion?
No, I believe there's different ways that the association's attorney could prove it. For example, if at this trial, if at the actual trial, the note that was entered into evidence was a note that was payable to the payee, the original lender, and there was no endorsements on the note, then it's entirely possible that this bank never had possession of the original note at the time the complaint was filed because it's impossible, because it's payable to somebody else. So there is ways to prove it. The association just didn't do it in this case. Another example would be, I do a lot of evictions, and in evictions there has to be a 3-day notice served as a condition precedent to filing the eviction. If attached to the eviction complaint there is a notice that only gives 1 day, and there was never any other notice given other than that 1-day notice, the landlord would never be able to prove that it actually satisfied that condition precedent. And that would be the notice that, in my example, the tenant would use, and in this example, the HOA would use at that fee hearing. There is evidence, and the judge in this case exercised her discretion in denying the 57-105 motion and determining that it was not frivolous. If the court is going to enter if the court is going to reverse, we're saying this should be affirmed, it is going to have a chilling effect on lawsuits in Florida. Every time a bank files a foreclosure complaint or any other type of plaintiff files a foreclosure complaint and gets a 57-105 served, possibly on standing, it's possible that these banks won't file these cases anymore, or these plaintiffs won't file these cases anymore for the risk of...
They'll actually prepare for trial.
Well, that's what the legislator amended the statute, so there's new rules on what needs to be pled when you're filing a mortgage foreclosure complaint.
Pleading and proof are two different things, and that's why the statute says at the time you filed it, I believe, or before trial. So there's an or. And so before trial, you're looking at your file folder, and that's why I prompted my other question. If counsel's looking at it and saying, I have to prove a pooling and servicing agreement, and I don't have a signed copy of it, I don't have a certified copy of it, I have no copy of it, and I elect to go to trial, well, that's not admissible evidence. Now, by itself, I would probably agree with you that that may not be entirely dispositive. I'm just using it to make my point. There comes a point where counsel has to do something and be not just an advocate for a client, but remember the other hat counsel wears is an officer of the court. And you're coming in here and say, I don't have any evidence, but here we are, maybe I'll get lucky and you'll let it in.
Well, I think this is a unique case because what happened here is in 2009, I believe is when the 57-105 motion was served. And at that time, it's entirely possible and likely that
And they have to prove one of the two time frames under the statute or the rule. At the time of the filing or before trial. I don't think the statute says 57-1 or trial. It says at trial. I think the magic words that I noted were when initially presented to the court or at any time before trial. And those seem to be the temporal points that the motion ought to articulate and the proof ought to establish. Would you agree with that?
I would
If
agree,
they
Judge.
didn't prove either of those 2 points in time, then it can't be an abuse of discretion on a failure to prove, or if it's subject to contest, we would give deference under an abuse of discretion to the trial court.
In this case, though, in 2009, when the 57-105 was served and provided the 21-day safe harbor, the bank could evaluate that motion and determine, we have the evidence at this time to prove it. And then 6 years later, when the bank went to trial, the bank isn't going to just dismiss the case. It could,
Isn't
but
that
it
its duty? I mean, isn't that what this is about? At some point in litigation, you realize you suspected at the time, and you had a good faith belief when you filed the complaint, that this was going to lead to a ruling in favor of the plaintiff, but there's a point in time when the light bulb goes off that you can't prove it. The fact that you just stated that the bank isn't just going to dismiss it is the most disturbing thing I've heard in this argument. It shall not proceed without merit that it could prove up its claim.
Your Honor is correct. Your Honor is correct.
I mean,
What-
there is zealous advocacy, and then there's a duty to the tribunal and to the ethics here.
What I meant to say is that the bank was not able to obtain a signed pooling and servicing agreement before the trial. But that doesn't mean that they didn't actually have standing at inception to pursue and attend the trial. And the witness was not able to testify when the original endorsements were put on the note. And therefore, the bank lost that standing. But it was a failure of proof. It wasn't a frivolous claim. It wasn't that they didn't have it. They just weren't.
Did the bank think it was, that the document was signed when it went to trial that day? On the pooling agreement?
I don't know. I wasn't the trial attorney. I don't know if it.
But it wasn't.
No, then
I
it
mean,
was.
it goes to
was
Judge
not.
Casanova question. I mean, I understand the finding that it goes to a failure of proof at trial. However, short of asking the attorney to admit that she or he is frivolous, isn't it true that you knew that it wasn't signed? What's left on this record, on the face of these documents without evidence, to lead us to conclude that the bank proceeded forth not in contravention of 57-105-1?
The signed stipulation where the borrowers agreed that the bank had standing and consented
That
to the
wasn't at
judgment.
trial.
It wasn't at trial, but it was the basis for the motion for rehearing, which the trial court granted the motion for rehearing.
understand.
And then that was affirmed when the association.
That's when the light bulb went off.
That's when the, so.
Understood.
I mean, the second DCA affirmed and reversed and remanded solely to make sure that the HOA's lien wasn't extinguished. But in affirming, the appellate court determined that the bank did have standing.
Thank you, sir.
If there are any further questions, thank you very much.
Thank you very much.
Thank you, counsel.
I won't belabor this much further. I want to point out, because we've talked about abuse of discretion, but as I said in my statement of the standard of review, except where the court misapprehends or misinterprets the statute, Judge Taylor, I believe, was interpreting the statute pre-1999, and that was everything was measured as of the date you filed the complaint. Everything else was irrelevant. 1999, we amend the statute to say that at any time before trial. And then, Brenton versus Ferrara, the court emphasized it. Quote, once a party learns its claim or defense is not supported by the facts or law, it must drop the claim or defense or risk imposition of Section 57.105 attorney's fees on the non-meritorious claim or defense. And as I say, this court had the same thing. So basically, Judge Taylor is basing it on the pre-1999 version of the statute. Oh, they had a good faith attempt at the time of commencement, but it just kind of fell apart during trial. 1999, well before this case is filed, the law changes and says Yes, when the light bulb goes off, you have to make a determination, can I go forward or not? And on the basis of the record below, keeping in mind, 57-105 is determined on, the burden is upon me to either prove at the hearing by testimony or the record below. And the record below, as I say, has a trial with only 4 documents in it, and those 4 won't prove standing, and the testimony of their sole witness at trial who can't date the endorsement. So,
There are at least 2 districts, the 3rd and the 4th, that have taken the position that a party does not need to have conclusive evidence to prove its case at the time of filing an order to avoid sanctions. Where a party reasonably believes that the factual basis for its claim exists, it's entitled to proceed with its claims and seek to prove those facts. If attempts to prove those facts are fruitless, that is still not a cause for sanctions, where their initial belief was well-founded. And so, if we look at this record, and the trial judge scours the trial record, we might have to say that if there's any ambiguity, and then the standard of review is abuse of discretion, that perhaps the trial court is right, because I'm not sure that we know over this long period of time what took place.
yes, except over this long period of time, we know that they weren't able to prove the case.
So
In
we should
6
then
years, they
focus-
should make a
So
determination.
then we should focus and say that just before trial, this should have been clear, because just before trial, they would have known what bullets they could load into their guns, so to speak.
That's exactly why the statute was changed, because at the time they filed the case, they had a better case at the time they filed it. They were saying, we've lost the note. That explains why I don't have a complete copy of the note to attach to the complaint. Maybe they would have tried it, but 2 years after they file, they find the note. And now we've got a different case, and they don't reevaluate what their evidence has to be. But this court rejected the good faith, bad faith, dichotomy back in the in re forfeiture of 1999 Jeep Cherokee, where the court said, well, the city of St. Petersburg acted in good faith. They didn't act in bad faith. And the court said, no, it's not good faith or bad faith, because I believe every attorney, as an officer of the court, when they file the complaint, has a good faith belief that they have a good claim. But it's after 6 years, somebody has to step back and say, this case fell apart, and prior to trial. Judge, in South Bay Lakes...
You got to wrap it up pretty soon, Mr. Conklin.
I'll end it with this. In South Bay Lakes Homeowners Association versus Wells Fargo, this court, Judge Altenberg, said, the undisputed facts at the hearing established Wells Fargo was required to take a voluntary dismissal of this action or some other appropriate action during the allotted 21 days, that it had no right to compel the association to proceed to judgment on the motion for summary judgment. The point they, again, emphasizing, it's not the pre-1999 statute. Everything's measured from the commencement of the case. It's commencement of the case and at any time prior to trial. Thank you very much.
Thank you.